All right, ladies and gentlemen, we're back on the record. This court has considered the motion in limine and the evidence that's being offered and makes the following findings in it. For the record, I am relying principally upon a Tennessee Supreme Court decision.
Recording in progress.
Tennessee Supreme Court decision, State versus Franklin, 308 Southwest 3rd, 799, a 2010 decision of our Tennessee Supreme Court to help explain. And also I'm relying upon the State versus Stout case, which has been cited by the state in this matter. And in any event, I'm not sure it's, 46 Southwest 3rd, 689, a 2001 decision of the Supreme Court. So I'm principally relying on State versus Franklin. The first issue is whether or not the statements of the child and the aunt violate the right of confrontation clause as being testimonial in nature. And under the decisions of our Supreme Court, and principally the State versus Franklin, if I can find my reference to it, any testimonial statement of a witness absent from a trial is inadmissible under the Confrontation Clause unless the declarant is unavailable and the defendant had a prior opportunity to cross-examine the declarant. However, non-testimonial hearsay is not subject to the Confrontation Clause of the United States. The Supreme Court in this case goes on to help us by defining what are testimonial and non-testimonial. Statements are testimonial rather, and thus subject to the Confrontation Clause when the circumstances objectively indicate that there is no ongoing emergency and that the primary purpose of the interrogation is to establish or prove past events potentially relevant to later criminal prosecution. In this case, and it goes on to say that statements are non-testimonial and thus not subject to the Confrontation Clause if the primary purpose is something other than establishing or proving past events potentially relevant to prosecution, such as providing or enabling assistance to resolve an ongoing emergency. And this court's opinion, and I find as a matter of fact, that this is a non-testimonial statement of the child and the aunt because there was an ongoing emergency. This testimony had been that there had been numerous individuals there, that there was an ongoing investigation into this missing child, that the witnesses in particular were there to fill out a missing or to assist in filling out a missing child report. And therefore, it is this court's opinion that it was a non-testimonial statement, so it would not be a violation of the defendant's right of confrontation to admit the statement. So I then move to the question of whether or not there is a hearsay exclusion of this rule. The state argues that it is an exception to the hearsay rule as an excited utterance. And our Supreme Court has further stated that in order for a statement to meet the excited utterance exception to the hearsay rule, a statement must first meet three requirements. First, a startling event or condition must occur that suspends the normal reflective thought processes of the declarant. Second, the statement must relate to the startling event or condition. And third, the declarant must make the statement while under the stress or excitement of the event or condition. It does have a competency. The excited utterance exception to the hearsay rule has a competency requirement. That is, that the declarant must have had an opportunity to observe the facts contained in the extrajudicial statement, which I take is what Mr. Taylor has been arguing in his particular situation. The Supreme Court goes on to state, though, that the startling event relied upon for the excited utterance exception is typically the act giving rise to the underlying legal controversy. A subsequent startling event or condition which is related to the prior event can also produce an excited utterance. In the Franklin case, a lady was assaulted and the individual left the business, and as he was leaving, a contractor next door was working, and the victim of the assault asked the contractor to try to get the tag number of the vehicle that he was leaving in. So he wrote down the tag number. At trial, that witness did not testify. The man who wrote down the tag number did not testify. The state sought to introduce the tag number, and the defense objected as being hearsay. Supreme Court ruled that, number one, it was non-testimonial because it was in the process of it didn't meet any of the criteria to be confrontational. or testimonial rather. And then it went on to talk about whether or not it met the definition of an excited utterance. And they talk about different things, but basically it says that the first requirement of a startling event must relate to suspends the normal reflective thought process of the declarant. Second, the statement must relate to the startling event, but this broad requirement offers considerable leeway such that the statement may describe all or part of the event or condition or deal with the effect or impact of that event or condition. And then it says that the third and final requirement dictates that the declarant make the statement while under the stress or excitement of the event or condition. This requirement considers a variety of factors, including the interval of time between the startling event and statement. Underlying the excited utterance exception is the theory that circumstances may produce a condition of excitement which temporarily stills the capacity of reflection and produces utterances free of conscious fabrication. In that case, it cites the Land case, which is one of the cases cited by the defense in this case. Supreme Court goes on to state the following: we have described the ultimate test of whether a statement meets the excited utterance standard as spontaneity and logical relation to the main event, and where the act or declaration springs out of the transaction while the parties are still laboring under the excitement or strain of the circumstances and at a time so near it as to preclude the idea of deliberation and fabrication. They went on to hold that that introduction of that tag number was, in fact, an excited utterance exception and allowed that that tag would be admitted under the rules of evidence. In this case, the court finds that the child and the aunt were in the house at the time of the alleged whatever took place, the event that took place in this situation that led to this child being missing. They were there in the house. The testimony at this point in this case has established the number of people who were inside the house and their identity. Noah and the aunt were in the house at the time. Regarding Mr. Taylor's argument that there's no proof that they had an opportunity or that they actually witnessed anything, that is true. There's no proof thus far that they witnessed anything, but it is proof that they were inside the house, and this house, from the descriptions that have been seen by video and photograph, is apparently a fairly modest mobile home, possibly small structure, so that the individuals inside the home could have very easily been witnesses to something that occurred. They may not have. But the fact of the matter is they had an opportunity in this court's mind to observe something. Secondly, even though this occurred at a later in the morning, the statements occurred later in the morning, the court finds that it was a situation where there were numerous individuals on the scene, that the investigators that have testified this morning were there to complete a missing child report. The child at 3 years of age that came forward would clearly have been laboring, in this court's opinion, under the excitement of all of these investigators and all of these people being in the house and the unusual circumstances that occurred, and that the aunt would have also been exposed to this type of situation. The aunt statement was a little more difficult for the court to determine. I think the child's statement clearly meets the definition in all regards of the excited utterance. The aunt's response, somewhat more difficult, but in reading this case law, the State versus Franklin in particular, it is this court's opinion that the aunt's response to the child could also be interpreted as an excited utterance. She responds to the child's statement, and in view of all of the commotion and chaos that was going on with the investigation, then this court finds that both the aunt and the child would have been laboring under the excitement at that time, and therefore could that these would meet the definition of excited utterance. So therefore, I deny the motion in limine. The interpretation of those statements is certainly an argumentative to the jury. You have the right to argue to the jury your own explanation of why those statements were made or however they were made. I do not find that the availability of those individuals as witnesses at trial is required to meet the requirements of an excited utterance. I don't see that in any of the case law, and specifically the State versus Franklin case that I cited the person who wrote down the tag number that was later declared to be an excited utterance was not called to testify at trial, even though he was a contractor and was readily available. And that was an argument that was made. The Supreme Court ruled at that point that it was nonetheless available. So based on all of those considerations, the court finds that the motion in limine should be denied.
Just for the purpose of the record, Your Honor, I would ask the court, what is the factual basis for the startling event that the court has found that these two individuals observed? What has there been in evidence so far that they observed anything that would be a startling event that might carry over to later?
All right.
And secondly, what time has been shown that the startling event took place, and what proof is there that Aunt Joycey or Noah witnessed any startling event in this case? Not whether they were there, but what proof is there that they witnessed anything happened that would have led to the death of Joe Clyde Daniels?
All right. In response to that, clearly, perhaps I didn't make it clear enough, but for Mr. Lockhart, I will. The startling event that I have described as being the event that this court attributes to and therefore accords the excited utterance to be established is the fact that this home was inundated by all of the testimony thus far in this trial, by numerous deputies, by searching for this child. Individuals there searching for this child. The defendant himself, according to the testimony, was out supposedly searching for the child. The two individuals that have testified entered the home with the purpose of trying to take a missing child report. All of that, in my opinion, constitutes a startling event. It does not require that the startling event be, that the excited utterance be directly related to the initial. It can be a subsequent startling event. For example, in the Franklin case, the court considered whether or not that tag number being written down was sufficiently connected to the event of the robbery that occurred for the victim, and the court said it related to that instance and that was sufficient. In other words, the woman who was assaulted and robbed came out and talked to the contractor and told him what had happened. He didn't witness it. All he knew is that she told him that there was that she had been assaulted, and she asked him to write down the tag number. He then wrote down the tag number, and that tag number was what the state then introduced, and as a result of that, it was considered to be an excited utterance by our Supreme Court. So there was no requirement in that case that the man who wrote down the tag number that later was introduced actually witnessed the assault. The startling event could be something subsequent to that, and the case law is pretty clear about that as well. The State versus Stout, which is cited by the state, goes on to say that it can be other times, something that can happen after the actual event. If you are attempting to say that an excited utterance could only be that the child witnessed something and then immediately made a statement, then I don't find that to be a requirement of the excited utterance. And as far as the proof that the child or the aunt had the opportunity to see or do that, again, State versus Franklin is pretty clear that the excited utterance is not required to be, it has to be directly related, but it doesn't require that proof be that they saw what happened. That may be an inference in the statement that was made, but nonetheless, I think that the findings that I have made are sufficiently factual under the State versus Franklin decision to allow this testimony to be admitted, and that is the ruling of the court. All right, are we ready for the jury?
Yes, sir.
All right, bring the jury in. When the jury returns, I'm going to first address the two questions that have been written and submitted by the jurors. Good morning, ladies and gentlemen. You may be seated. Thank you. As I explained to you, I had to take something up this morning before we got started with the actual testimony, and I've dealt with that situation. But before we begin the actual testimony, yesterday I was handed a note, may have been handed it this morning, but I think yesterday there was a note handed, and it had two questions on it. And they relate to a video that was demonstrated yesterday. The questions are, why can we not hear the audio? And then it goes on to say, why are there parts that the jury cannot hear? So that you understand, my job, it's been described somewhat as the gatekeeper. In other words, I am required, I'm kind of like the referee in a sporting event. There are rules that have to be followed. Those rules are written down in our rules of evidence and our rules of procedure. And I have to interpret those rules. So there are circumstances where one side says, you know, that shouldn't come in because it violates this rule. Okay, it's like a review of a touchdown and whether or not they actually cross the goal line, so to speak. But in any event, my job is to make sure that the rules are followed and that they are applied fairly across the board. Yesterday, when we had a hearing, if you remember, there was a hearing that was going to be about 10 or 15 minutes and it stretched out to be about 45 minutes to an hour, and y'all had to sit back there in that room. Well, that was so that I could tell these folks to make some changes that we called to redact. The term redact means to remove. And the way I've described it before is if you see some declassified documents from the government, it'll have black lines in it. That's a redaction. And what that means is that there is some reason that that information shouldn't be applied or supplied to the public. In this case, there were some things that were on that audio that I think would have been inadmissible in court, and as a result, under our rules that I have to apply. And therefore, I ordered them to omit that. And the simplest way was to just mute it. You could see the events, but you can imagine that if somebody's out there running their mouth or saying something that you don't need to hear as a juror, don't need to be exposed to, and don't worry about what was said or why I excluded it, just understand that I did what I thought was right. And for that reason, you were not allowed to hear some of those things, but you were allowed to see them. It was more important for you to see what was going on than to hear what might have been said at that time. So that's my responsibility. I've done what I think was the correct thing, and the parties cooperated with me in making those changes to that. So that's why you didn't hear it. We're not trying to hide things from you. We're not trying to keep you from being able to hear things that are important to you. As I've explained to you before, you will have to decide the case on the evidence that's presented, and only the evidence that's presented. It may be what evidence you don't think is sufficient or you think it is more than sufficient, but that's your decision to make. Right now, I have to decide to an extent if something should or should not come in. Does that explain it to you? All right. And again, if you have further questions, you can write them down and let us know. But right now, I believe that answers your questions. So we're going to go ahead and start the testimony again. State may call its next witness. Step right up, please. Raise your right hand. Face our clerk.
Do you solemnly swear or affirm that the testimony you give in this case to be the truth, the whole truth, nothing but the truth, so help you God?
I do.
Officer, if you'll speak directly into that microphone when you sit down so that we can be sure to hear everything.
Yes, sir.
Would you state your first and last name?
I'm Deputy Timothy Simmons,
All right. And how do you spell your last name?
Simmons.
All right. And where do you work?
Dixon County Sheriff's Office.
How long have you been employed there?
9.5 years.
What do you do at the Sheriff's Department?
I'm currently the canine handler for the Dixon County Sheriff's Office
How long have you been the canine handler?
since 2017.
All right. April the 4th of 2018, I want to draw your attention to that day. Did you get a call to respond to Garners Creek Road?
Yes, sir, I did.
All right. And you know what that call was in reference to?
A missing child.
Okay. And where were you at the time you got the call?
I was at home.
Okay. So you responded from your house?
Yes, sir.
You call about the time you got there?
It was about 7:30.
Okay. And is your car equipped with a in-dash car camera?
Yes, sir, it is.
And have you and I reviewed a couple of clips from that camera?
Yes, sir, we have.
All right, I'm going to play the first one for you here. I might play the first one for you here. And while they're doing that, Deputy Simmons, let me just ask you, do you recognize this being one of the clips that we reviewed?
Yes, sir.
And is this when you are responding first to the scene?
This is when I first arrived on scene. Yes, sir.
All right. And the residence would be to your right, is that?
Yes, sir.
Do you know whose vehicle that is right there?
That's Mr. Daniels' vehicle in the red Chevy that's fixing to pass.
Talking about the car, not
The car. Yes, sir, the car.
All right. Is that you right there, Deputy Simmons?
Yes, sir, that's me that morning of.
Deputy Simmons, do you know who that is?
That's Miss Daniels, Crystal Daniels.
And did you see or do you know if she got out of the vehicle with the defendant?
Yes.
She did get out of the vehicle with the defendant? Okay. And is that the defendant's vehicle leaving again?
Yes, sir, it is.
And does it continue south on Garners Creek?
As far as I know.
All right. So after you arrived on scene, after this video clip here, what did you proceed to do?
I tried to explain to Miss Daniels who I was and what I was there for.
And what were you there for?
I was there to help track using dogs to hopefully find the young missing child.
And is your dog? What does your dog do? What all?
My dog is a dual-purpose narcotic patrol dog, but she also tracks. I was trying to explain to her that I wanted to use my dog as a last resort because my dog does bite.
Your dog is a bite dog. A dog
yes,
that's
sir.
trained to do
Yes,
that.
sir.
And were there other dogs available that you could get?
Yes, sir. I called for Dixon County EMA. They have a search and rescue dog, and I called for that dog to come out, and that's who I was planning to work with.
Okay. So obviously, you didn't want your dog going and biting.
No, sir.
Okay.
I didn't need us to be on the news because dog bit the child.
Sure, absolutely. Did EMA arrive on scene at your request?
Yes.
Okay, and then what all did you do with that?
We went up to the residence to talk to Miss Daniels about getting a scent article for the SAR dog.
And was one provided?
Yes, one was provided.
Okay. And then what? Then what did you do?
We used the scent article to start our track. The SAR dog started in the backyard of the house. We went along the fence line. There was a bunch of trees. We went along the fence line, led out to South 3rd Street. We came upon a rock home.
Let me stop you there for just a moment, just to kind of get everybody's bearings. So if I'm standing looking out the back door of the residence, this fence line and tree line is to the left, is that right?
Yes, fence line's to the left, and it goes at an angle,
Okay.
sort of leading to the right, but it's leading out to the South 3rd Street.
And South 3rd, is there a road directly behind the house?
I believe it was Lane Road.
Okay, and then there's a road, South 3rd, is that off to the right of the house if I'm standing on the back porch looking out this way?
You got South 3rd, you got Garners Creek, which is where the residence was on.
Right.
And then the rock house that we led up to, Lane Road, is on the other side of South 3rd.
Okay, all right. So the dog ran along the tree line and then ran towards this
Brick
driveway
home.
ran toward after that.
We went towards the brick house, and we ended up in a pond area behind the residence. The dog lost its track around that water, around that pond. While we were there, we made contact with someone to get access to the brick, the rock home, because it was a vacant home. Just wanted to see if the boy somehow made it inside the house, so we cleared the house.
So you were able to get inside that house and search it?
Yes, sir.
Nothing
was found in there. While we were searching, I believe it was the trooper's hound dog, THP hound dog, that actually passed where we were at, going down South 3rd to McElhaney, which is the next road down.
Okay. Did you continue with the search down there?
After that, we gave them some time to pass. That way we didn't have two dogs on top of each other.
Okay.
We continued down South 3rd after we gave some time. We ended up on McElhaney Road, and we ended up going southbound on McElhaney. We stopped around there was a bunch of double wides that we just seen off in the field that weren't really put together. So we went out there. We searched those looking for the child. Obviously, we didn't.
Is that somewhere the dog tracked, or is that just somewhere you saw?
No, we just saw it, and we
Okay.
figured it was an area of interest.
Okay.
And we walked out there, and we went ahead and searched the buildings, and we didn't find anything out there. The dog track continued on down McElhaney until the dog pretty much was exhausted. And at that point in time, we had to give the dog a break and and stop the track.
Okay. And that pond that we referred to or we referenced earlier, was that pond later drained by other people, other personnel?
I was told so. I had left the scene prior to
Okay.
them draining.
So you weren't part of that?
No, sir.
All right. All right. And then I believe we have one more video clip to show you. Because your car cam, while he's getting that pulled up, your car cam was left running while you were kind of out of the
Yes.
scene. Is that right?
Yes.
Okay. So let's watch this clip. And is that the defendant's car that's just pulled up?
Yeah, in front of the Dixon County EMA dog team, actually, on the other side of the driveway.
And of course, this is sometime later in your video. Is that?
I arrived around 7:30, and the video is stating that that's 9:18.
Okay.
So,
And is that the defendant right there walking up the driveway?
yes, sir.
All right. So the first video we saw was somewhere around 7:30, and then this was about 9:18.
Yes, sir.
All right. Your Honor, as to the first, introduce a copy of the first clip we showed,
22.
Yes, sir.
and then 23 would be the second video clip.
Thank you.
Both of these are the dash cam video, right?
That's correct, Your Honor, just the two separate clips that we showed. And that's all our questions.
All right. Cross-examination?
The first scent that the dog picked up was going toward an abandoned stone building or rock building.
That's where the track led to. Yes, sir.
And just ballpark, how far was that from the Daniels residence?
I would say somewhere close to half a mile, maybe.
Okay. And then the dog continued to track all the way down McElhaney Road.
We were trying to get a decent track down McElhaney Road. Yes, sir.
And was the dog appear to be following a track?
Yes, sir.
Okay. And how long, generally speaking, would a track be there? If this child had walked toward the stone building, then walked down McElhaney Road, typically how long would that scent?
It depends on the weather. It really does. It depends on time, UV light, and it depends on the dog. You know, her dog is more set up for those long distance tracks and older tracks than my dog. My dog is more, you know, hey, they're running. We need to get a track started so we can catch them.
But apparently there was sufficient scent left for the dog to track down
Absolutely.
McElhaney Road.
Absolutely.
And how long a distance would that have been if the child walked down McElhaney Road?
We walked that dog for a couple miles. I know that.
All right. What was the scent article that was used?
I believe it was an article of clothing that was out of the dirty clothes hamper.
Okay. And in the video, you saw Mr. Joseph Daniels go in both directions, driving slow.
Yes, sir.
All right. And had he said anything about he was going to drive to see if he could see little Joe?
I never talked to him.
Okay. All right. Are you familiar with the darker blue-colored or black-colored vehicle that passed? Do you recall seeing that in the video?
You talking about the truck
No,
or the maroon?
not the maroon, but I'll see if we can pull that up on the video. Can you pull up that video again? Okay. I'll withdraw that question, Your Honor. We don't need it. Do you know how many dogs were out there working this scene?
At that time,
Yes.
right off the bat, I believe it was just two.
And
THP Hound Dog and Dixon EMA SAR Dog.
did you see other dogs later working the area?
I left shortly after we were done with the SAR Dog. I didn't stay on scene very long because it was my day off, and they told me they didn't need me at the time.
Okay. Nothing further, Your Honor.
Be direct.
Just briefly, Judge. So, Deputy Simmons, it's hard to say how long a scent could stay there. Is that fair to say?
That's fair to say.
We can't say it was just made, or we can't say it was made a long time ago.
No,
It's
sir.
hard to say. Okay. And at this point, y'all were looking for a missing child. Is that accurate?
Yes, sir.
This was not like a trying to find a body. Y'all were looking for a missing child.
As far as I knew, that's what we were looking for, was a missing child.
That's all.
Recall.
If a long period of time passes and you have weather conditions such as rain and that type thing, you'd be less apt to pick up a scent. Is that correct?
Water actually holds odor.
Water does? Okay.
Yeah, water holds odor.
And as far as a time factor, you can't judge when that scent would have been left.
No, sir. Like I said, my dog tracks, usually we're tracking someone who just ran.
Okay.
SAR dogs are trained to do the older tracks.
And your information at the time was this child had escaped from the house and took off.
As far as I know, that's all I knew, was the boy had wandered off from the house, and all I was doing was helping search for a missing child.
And based on what you saw with your dog, it tracked that boy's scent down McElhaney Road.
I was trusting the handler. It's not my dog. So I have to trust the handler that was working the dog. I was just there to support her.
But you have a dog.
Right.
You've seen him work.
Yes, sir.
And based on what you were seeing, that dog was tracking Joe Clyde Daniels down McElhaney Road.
He was tracking odor.
Odor of Joe Clyde Daniels.
He was tracking odor. I'm going to assume it was Joe Clyde Daniels, but
Because that's who you're trying to track.
that's who we were trying to track. But again, not my dog. I was there as support.
And the scent article that the dog used
Was Joe Daniels.
Joe Clyde Daniels.
Yes, sir.
That's all the questions I have.
Be direct.
Judge, I don't have any redirect, but we may have a juror with a question.
Question. All right, ladies and gentlemen, if you'll step out to the jury room, as I told you, the procedure is anytime you have a question for a witness, you just need to pass it down to the bailiff standing at the end, and then he'll hand it in to me, and then I have to take it up outside your presence in front of the lawyers, and then we'll come back to you, okay? Thank you.
Judge.
All right, I have been handed two questions. Let me remark to you that we have a very intelligent jury. My interaction with them is that they're a very intelligent group as a whole, and they have questions. They're probably going to have a lot of questions throughout this trial. First question I was handed was in specific, I think, for this officer, and it says, were there other clothes in the hamper, and could this hamper the smell for the dog? I don't know. I mean, this officer can't testify where that came from, but the question could be asked as to whether or not if the article of clothing had interacted, with another article of clothing, could that have affected the dog's smell? Either side wish to argue that or to ask that question in some form?
Judge, we anticipate more proof will be put on clothing, dirty clothes hampers. Part of the proof they've already heard, further to that, body cam.
If you, I think in order to make this record, I need you to go to the podium. So.
There's already some proof in the record, Your Honor, from the body cam of Deputy Dearman. You can hear Deputy Bledsoe retrieving an article of clothing from the dirty clothes hamper, but there will be additional photographs and testimony about retrieval of items.
Well, the question that I think the juror is asking of this witness is, could an article of clothing that came from a hamper affect the dog's smell or ability if that article of clothing contained more than one smell, is what I take from that.
And I think that the witness should be allowed to answer that question.
All right. Mr. Lockhart or anyone from the defense have any input on that?
Just like to question the officer a little bit.
All right, go ahead. While you're walking to the podium, the second question I don't think relates to this particular officer. One of the jurors asked if they could get an overview map of the area. And that's not a question, I think, for this officer, and it's not really a question that I can answer. I'm just going to, I will advise them that the evidence that's presented to them will be as you put it on, and that I can't require you to put on other evidence. The state will put on evidence, the defense will put on evidence, and they decide the case on that evidence. So.
And you can tell them that it will be introduced later
All right,
on. I mean,
that's
the state's going to introduce it.
All right. Go ahead and ask your question.
Do you know who brought the scent article to you?
Honestly, I can't recall.
All right. And if that scent article was touched by the person who brought it to you, the dog will still be able to track the main scent on that article. Is that correct?
That's the theory, yes, sir.
Otherwise, if anybody picks it up and hands it to you or the dog handler, that dog is not going to be able to track the scent on that clothing because somebody else touched it. I guess what I'm getting at, if somebody hands you a scent article, even if that person who brought it to you was someone else, the dog can still track the predominant scent on that article.
That's the theory, yes, sir.
And so, officer, the question I think that I would, and I'm proposing that I ask the question in the following form when the jury returns, and that is, the jurors have asked a question, and that question being whether or not, if the article of clothing that you were given as a scent article had been taken from a hamper where there are other individuals' clothing there, would that affect the ability of the dog to trace that particular scent? If you know.
I'm going to say anything's possible, but I really don't know. But that was a article of clothing that was supposedly on Joe Clyde's body.
All right.
And that would be the main odor that should be on that.
All right, and that's what Mr. Lockhart was asking you. Any objection to my asking the question of this officer, and then you can follow up with him as you wish?
No.
All right. Then we are ready for the jury to return. What kind of dog, while we're on a break, what kind of dog do you have?
I got a little Dutch Shepherd.
It's a biter dog, you know.
I was just glad he didn't bring his dog with him under those circumstances.
She's hopefully at home sleeping. We worked last night, so. Excuse me.
Well, this question doesn't, y'all have a seat, thank you. This question doesn't require me to do the others, and this is a request from the jury. If we are showing something on the screen, and when we set this up, I remember us talking about that, whoever's standing at the podium, defense or state, if you're showing something on the screen, if you will move away from the podium, what's happening is you're blocking the view that the jury has of that. So let's just try to keep that in mind. So, all right, ladies and gentlemen, I was handed, other than that statement, I was handed two questions. I'm going to deal with the easy one first. Can we get an overview map of the area? I'm told by the lawyers that that will be presented at some point during the case, so that should solve that problem. The second is a question that was given to me, and I'm going to alter slightly the question so that I think it'll get the essence of what was requested. Officer, there were, and this is a question the jurors are asking, there was a scent article, an article of clothing given to you. If that article had been taken from a hamper, a clothes hamper, where other clothes belonging to other individuals was in that hamper, would that have affected or hampered, no pun intended, it would have made it more difficult for the dog to follow the scent?
The hope is that the clothes were on Joe Clyde. We as people shed skin cells. It shouldn't interfere because the odor should be trapped inside the clothing.
I'm going to allow the lawyers to follow up with any additional questions they may want to ask. Does either side wish to ask any additional questions? We'll start with the state. All right, Mr. Lockhart.
These type dogs are trained to sniff a scent article and then follow that scent.
Yes, sir.
And in most of those cases, you don't have a robot or something pick up a scent article and hand it to you.
No, sir.
So typically, some person other than the one you're looking for is going to pick that up and hand it to the dog handler.
More than likely.
All right. And the fact that somebody held it in their hand or is in a hamper, the dog still is trained to follow the predominant scent.
That is correct.
And a predominant scent on an article of clothing from Joe Clyde Daniels, because of skin shedding, that type thing, would be Joe Clyde Daniels.
Yes, sir.
And based on your training experience, the dog would then follow that predominant sense.
Yes, sir.
Nothing further.
Anything further from the state?
So, Deputy Simmons, do you recognize this area here?
Yes, sir.
All right, and
Judge, when we're questioning witnesses and the jury needs to see the screen, we have permission question?
I'm sorry. I apologize.
In order to not block the view, may we question the witness from counsel
You
table?
may.
Thank you.
Ladies and gentlemen, if you've got something on the screen, what I'm going to do is have them stand at the council table. I think that was a good idea. That'll clear up the screen for you. So just bear with us. That's a little different than what we normally would do.
So Deputy Simmons, do you see like the triangle of roads there, roughly a triangle?
Yes, sir.
Which one is Garner's Creek Road?
Garner's Creek Road is the road that kind of comes down and then veers to the left. Well, yeah, if I'm looking at it, it veers to the left and keeps on going down.
Okay.
Would it assist the jury to have him stand and point to
Yeah, I believe so, Judge. Deputy Simmons, if you would do that, please.
I don't have anything to help you point with except my gavel. You can walk in the
Use my hands. This road right here,
We're struggling this morning.
this road right here is Garner's Creek.
Okay. And then would you point out South Third for the jury?
This is South Third.
And the approximate location of the rock or stone house that you were speaking of?
I believe it's right here.
And that's the pond that the dog
Yes, sir,
trapped
that's
to?
the pond.
And then is the red mark that's there, is that the location of the Daniels house at 1112?
Yes, sir.
All right. So you tracked from the Daniels, or if you would on the map, just kind of show us where you tracked.
Back of the residence, along this tree line, up through the field. I believe there was a fence line around this house. We came through the front to the pond area, and that's where the dog kind of had a little bit of an issue.
Okay. That's my questions, Judge.
Mr. Locker, anything further?
Nothing, Your Honor.
Thank you, sir. You may sit down. Are we finished with this witness?
Yes, Your Honor.
Thank you, Deputy. You may be discharged and return to your duties. All right. Statement 21.
State calls Brent Morse.
Come right up here, Mr. Morse. I'm going to ask you to raise your right hand. Let me place you under oath. You solemnly swear from the testimony you're about to give in this case to be the truth and nothing but the truth, so help you God.
Yes, sir.
All right, thank you. Have a seat, please.
Mr. Morse, will you state your full name for the record, please?
Yeah, Brent William Morse.
Thank you. And you spell your first and last name?
Yes, Brent, B-R-E-N-T, Morse, M-O-R-S-E.
Thank you. And Mr. Morse, where are you employed?
I work for the Tennessee Emergency Management Agency.
Thank you. How long have you been employed there?
19 years.
19 years. And
Yes.
what's your current position?
Current position is Regional Director over the Middle Tennessee.
Regional Director over Middle Tennessee?
Yes, sir.
And would you give us a brief overview of what TEMA is and what TEMA does?
Yes, sir. It is the state's coordinated agency for preparedness, response, and recovery for disasters and emergencies for the state.
Okay. And what specifically do you do for TEMA?
I have, there's 38 counties in Middle Tennessee, and I have 7 district coordinators that work for me, a regional planner, and we do trainings, we respond to disasters, and we help counties prepare for and recover from disasters.
Okay. And on April the 4th of 2018, were you in your current position as Director over Middle Tennessee?
No, sir.
What position were you in there?
I was a district coordinator.
District Coordinator.
Yes.
And did you respond to Dixon County?
Yes, sir.
And how did you get the call to go to Dixon County?
I was got a call from the district coordinator that was on scene, Michael Reinhardt. Told me he was working in Dixon County on the lost autistic child, and he asked if I'd come up and give him a hand. I was going that way anyway, and I stopped by the address. And
Okay. So do you know about what time of day you made it to the address on Garner's Creek?
12:30, 1 o'clock.
On April the 4th?
Yes, sir.
All right, so afternoon,
Yes.
around 12 to 1.
Yes, sir.
And when you first got to the Garners Creek area, did you stop at the command center or did you go directly to 1112 Garners Creek?
No, stopped at the command center.
All right, did you get a briefing at the command center?
Got a briefing from Michael Reinhardt.
And that was your director at the time?
No, sir. He's district coordinator at the time.
Got it.
So,
And after you got a briefing from Mr. Reinhardt, where did you go?
at that time, we kind of just stood around the command post. Mark Blackwood and Murray County SAR arrived. Michael Reinhardt briefed them on that. We made contact with a deputy sheriff from Dixon County, and we proceeded to go over to Gardner address, do a lost person questionnaire with whoever was there, mother and father.
So your assignment after the briefing was to go complete a lost person questionnaire?
Yes, Mark Blackwood asked me if I would assist with that.
And I'm going to walk through a couple of photos and
Sure.
Direct your attention to the screen. Do you recognize this photograph as being the address?
Yes, sir.
Is that 1112, the Daniels in Austin?
Yes,
I'll move. Is this photograph what you see on the screen?
it is.
Move that as the next exhibit, please.
Mark is exhibit 24.
If you'll hand that to the clerk.
Yes, sir.
Thank
You're
you.
welcome.
Mr. Morse, can you identify this photograph?
Yeah, that's the house.
Okay.
Yep,
That's 1112 Garner Street.
it
correct?
is.
And is that the front view of the home?
It is.
I'll move that as the next exhibit.
25.
Mr. Morse, can you identify this photograph?
That's the back of the house.
All right. And is the photograph you're holding the same photo that we see on the screen?
It is.
Move that as the next exhibit.
26.
Mr. Morse, can you identify this photograph?
Also at the residence.
Okay. And I want to draw specific attention to what appears to be a pickup truck.
Yep.
What's in the back of the truck?
Junk, garbage.
And going a little bit out of order, did you do anything with the garbage in the back of the truck?
The Murray County SAR team, after the lost person questionnaire was completed, we went outside and they proceeded to search the property, anything on the property, the fence line along the property, the ditches. The truck was completely emptied out.
All the garbage bags?
All the garbage bags was emptied, all the trash was emptied out. Looked underneath, and then everything was placed back into the truck.
Okay, thank you. I'll move that photo as the next exhibit.
27.
And Mr. Morse, can you identify this photograph?
That's the back entrance into the house.
And is this the entrance that you used to go into the house?
Yes.
All right, move that as the next exhibit.
28.
Mr. Morse, can you identify this photograph?
That's the indoor, that's the inside of the same door.
Okay. And I'll direct your attention to the top of the door where we see what appears to be a latch.
Yes.
Did you observe that on
Yes.
April the 4th?
It was pointed out to us by both the mother and the father.
It was pointed out to you
Yes.
by the defendant?
Yes, sir.
I'll move that as the next exhibit.
29.
And Mr. Morse, can you identify this photograph?
That's taken from inside the house.
Okay. And Mr. Morse, when you entered the rear entrance, is that the door we see in this photograph? The rear entrance?
Yes, sir.
And did you see what appears to be toys and whatnot in the floor?
Yes.
Was there a small child or more than one small child present when you entered the house?
The first child I saw was an older child. I'm guessing 8 or 9 at the time. He had a AC/DC shirt on. He was there with his parents. And later, I witnessed a smaller child, probably 2 or 3
Okay,
at the time.
thank you. And before I move on, I want to move that as the next exhibit, please.
Exhibit 30.
And Mr. Morse, can you identify this photograph?
Yes, sir. That's also inside the house.
Is this appears to be just a view from further around in a room? Is that
Yes.
correct? More toys,
Yeah. Oh, yeah.
couch.
Yes.
Move that as the next exhibit.
31.
And the last photograph, can you identify this?
Also in the living area of the same house.
And Mr. Morse, can you describe what this is?
It's a hutch,
Do you know what was on the other side of the hutch?
a door.
Would that be the front door to the residence?
I believe so. Yes.
And I don't know how well you can see this, but do you see an image here?
I do.
Is that a reflection?
Yes.
And what are we seeing in the reflection?
Looks like a human.
Do you see a face here?
Yes. Yeah.
Is that one of the children you saw?
Yes.
What about a face here?
That looks like the older boy.
Is that an AC/DC shirt?
It is. Yeah.
And do you see a deputy here?
I do.
A person?
Yeah. Another shape of person. Yes.
Thank you. I'll move that as the next photo.
33? No, 32, I'm sorry.
Okay, Mr. Morse, you
Yes.
have already testified that the purpose of you going to the residence, one of the primary purposes was to complete a lost person questionnaire.
Yes, sir.
Well, what is that? I mean, that sounds kind of obvious, but
Well, it's a document that has been around for a while that we use. We teach a lot of search and rescue at TEMA, and we teach that form, and we use that form when we have a person that's missing. It's broken up into, I think, 8 or 9 sections, and they have certain questions that are asked for each section. Anything, the demographic of the person that's missing, age, weight, height, what they're wearing, what they were doing, their trip plans, where they were last seen. It's probably about a 5 or 6 page document that we go through to try to get a better idea on what the lost person, who they are, and what they were doing prior to going missing.
when you entered the residence to begin the questionnaire, was the defendant present?
Yes.
Okay. Was the mother, Ms. Crystal Daniels, present?
Yes.
Was the Aunt Joyce Austin, present?
Yes.
Was Noah present?
Yes.
And I think you've already testified that Alex, who was wearing the AC/DC shirt, was he present?
He
as well?
was.
Okay. Was there anybody else in the house that is part of the family or friends, non-law enforcement, non-search and rescue?
Yes, there was a gentleman that I never saw his face, just the back of his head. He was sleeping on a couch in front of the television.
Somebody was sleeping on the couch in front of the television.
Yeah.
Now, when you started this questionnaire, did you sit down or were you standing? What were you doing?
Sitting down, Mark Blackwood had the document, and both of us were asking questions.
So you and Mr. Blackwood sat down in the living room area?
Yes.
And Mr. Blackwood was holding the document?
He was writing the notes. We were both asking questions.
And were any statements made by Noah or Alex?
Alex, not that I recall. Noah, yes, there was.
What did Noah say?
Noah had come into the room. That's the first time I recall seeing Noah. He had come up to my right, and he had stated or asked more, "Joe dead. Joe dead. Joe dead." And elderly lady that was there in the room with us said, "Yes, baby, Joe dead."
I want to make sure I get this clear. Were you asking questions of Noah?
No.
He just entered the room?
He entered from the back and on my right, asking that 3 times. Yeah.
He walked in and 3 times said, "Joe dead?
Yes.
Joe dead?
Yes.
Joe dead."
Yes.
And you, in your testimony, is that what happened after that?
The elderly lady, Aunt Joyce, said, "Yes, baby, Joe dead."
And
Then she reached down and picked up.
Noah?
Yeah.
Okay. What did you do when you heard that?
I looked over at Mark Blackwood He looked at me, realizing what we had heard. Nothing was said. The parents then came back and entered the room. They were out. The question was asked if Joe Clyde had a favorite blanket or a toy that he kept, and is it present? Did he take it with him when he left? And they went to go look for it, so they weren't present in the room. And they came back and said, no, his blankets, I think it's a Buzz Lightyear blanket, is here.
Let me be clear. Were the defendant and Crystal Daniels in the room with you when Noah made the statements, Joe dead,
No.
Joe dead? They were not.
They were not.
They had gone out of the room in search of an item of,
Yes.
of Joe Clyde?
Yeah.
Okay. Were any more statements of Noah or Aunt Joyce along that line made after the defendant returned to the room?
No, sir.
All right. Did you go forward completing the lost person questionnaire?
We did.
And after the
Assignment was to search the residence, to include the residence itself. I think Mark Blackwood's SAR team did that, Murray County SAR. The crawl space, there were 2 barns, kind of small outbuildings were searched. Of course, the truck that we talked about was searched. The property, if you see the front of the house, it had some high grass. The fence line was searched. That tractor, saw the tractor trailer, the tractor part was locked. That could not be accessed. The playground, there's a little sled and slide and swing set there was searched. The front of the property, somebody found the sewer system was open, is enough for a child to fit in. It was full, surrounded by grass. We went to the deputy that was with us and asked him if he could have it pumped. And he took care of that. He went and had that done. And I don't know who came out, but about an hour and a half later, a septic truck came and did pump the sewer, the septic tank.
So as part of the search of the Daniels residence, the septic tank was pumped?
It was.
Did you view into the tank after it had been pumped?
I did.
And what did you see?
No, there's no,
All right.
just an empty.
How long did you spend at 1112 Garner's Creek in conducting this search?
Probably an hour and a half.
Did that complete your assignment for that day?
Yes.
Thank you. I'll pass the witness.
Cross-examination.
Mr. Morse, what time of day did you arrive?
Between 12:30 and 1.
And what time of day was it when you were in the house with the family?
Sometime after probably 2:30.
Now, how many people total were in the house?
The mother, the father, the gentleman sleeping on the couch, the aunt, the 2 children, myself, Mark Blackwood. There was 8 in the house, and one halfway in the house, halfway out the door.
Were you aware at that point how many people had been on the scene?
Say that again, sir.
How many people had been on the scene at that point?
I don't know. There's a lot of responders there looking for Joe.
You talked about headquarters. Where was the search being coordinated out of?
It was being coordinated at the property. If you're facing the house to the right.
And do you recall where you were able to park?
I parked on the road in front of Gardner.
Was there a lot of cars there already?
There was,
So there's a significant number of people at the area.
yes.
It was said in 2 or 3 different ways here, but when Noah came in to talk to Aunt Joycey, he asked her.
He didn't ask her, he asked
He just asked.
out. Yes, he wasn't
So
directing
he's
it at
asking
her.
if he's dead.
Yeah.
Okay. At that point, had you witnessed anyone discussing the possibility that with Joe missing at that period, that he would be deceased?
No, sir. We were still under assumption we had a missing child.
So would it be possible that sometime during the 6 hours of searching that would have been discussed?
But not by me.
All right, we have two questions submitted by the jury, so ladies and gentlemen, you know the drill. You'll have to step out while I consider them on the record, and we'll come back to you. Just sit where you are. All right, I have two questions from the jurors. First question is, did Mr. Morse perceive Noah's words as a question or a statement? The second is, was the tractor trailer ever searched? Clearly, the second one of those is a question that's legitimate, and I don't have a problem with it. Either side wish to be heard about whether or not I should or should not ask that question. Well, let's start with Mr. Morse perceiving the Noah's words as a question or a statement.
I believe that was my last question. I don't know if that was something they asked before or after, but I asked him if it was a question or a statement.
Okay.
He responded to that, saying it was a question.
All right. And if that was asked, maybe I didn't miss it, maybe I misunderstood it. That was a question that you were asking, you answered that you perceived it was a question?
It was.
All right. And the second one about, was the tractor trailer ever searched? Anybody have any problems with asking that one?
He's already testified that it was locked, so
Pardon?
Mr. Morse testified the tractor trailer was locked, so they couldn't open it. So
Okay. Do you know whether it was ever searched at any point? Do you happen to know one way or the other?
No, I do not.
All right.
yes,
Then-
and Judge, it was searched, and we have video evidence of that search that will come on through another witness.
Well, what I'm proposing to do is to bring the jury back and make sure they understand that the first question was asked and answered by Mr. Mitchell and Mr. Morse right before we sent him out. The second question, I'm going to ask him if he knows personally, but I'll let them know that there will be further evidence on that issue. Anybody have any objection to handling it that way? All right. Well, I'll tell you what, let's go ahead and, we're ready for a mid-morning recess. Is there any reason we couldn't go ahead and take a short recess?
While the jury's not in, I would like to ask that moving forward, the district attorney's office is handing
Go to the podium, if you will. The reason for that is we're recording this as well
I
as
understand.
everything else.
Thank you. Moving forward, the district attorney's office is asking witnesses questions about photos, handing them photos to be identified, but before they even get the photo and attempt to identify, it's being published to the jury. Could we ask that those images be identified and that they actually can be authenticated through the witness before they're being published to the jury?
Certainly, what I would suggest we do, if you have a stack of photographs you want to demonstrate with the witness, show them to the defense. That way, if there's an objection before the witness is testifying, we can do that. And I think,
I have no problem showing them before we hand them to a witness on assume that there would be, in our multiple motion hearings, an objection to any photographs if they protested.
Well, I think that Mr. Mitchell's point is that if you could have the authentication of the photographs made before they're starting to be demonstrated to the jury. So I understand we're trying to move through. We have a number of witnesses. We're trying to move quickly, but let's, in response to Mr. Mitchell's request, let's just go ahead and have the state authenticate how the photographs were made and give the authentication, and then go forward. And by that point, I'm assuming you will have seen the photographs and understand which ones he's talking about.
Yes, Your Honor.
All right. Then let's go ahead and let's take about a 10 or 15 minute recess, and then hopefully we'll return at 5 after 11 so that everybody's on the same page. So. Let the jury know we're going to be in a recess for 15 minutes. So.
All rise.
Recording
This court is
stopped.
in recess.